Paulo, even though they're still very good. In Brasilia, it's a very small court system just because it's a local, it's just one city alone. If we consider the federal tribunals, the federal appellate courts, then they're all located in Brasilia. You don't have any choice. You have to be there.
And are the courts, on the days that the Brazil soccer team plays, are the courts open or closed?
Only if the judge is demented. It's a holiday, especially if it's a World Cup. It's a holiday, and if you have a deadline to file motions, they are suspended. You get extra time.
Wow. So let's talk then about the time and the efficiency of the court proceedings. If in civil litigation, are cases proven mainly through witness testimony or through documents? I mean, what's the emphasis of the proof?
It really depends on the nature of the case. You can use any kind of evidence that you want. The most important thing is that you have to present that evidence, or at least make reference to it when you file your original claim. You may ask for a certain document to be presented, but you have to present it yourself, or you have to ask the judge to send an order for someone to present it. It's not like in the U.S. when you have the right to seek documents from the other party. It's very important to notice that in Brazil, the discovery proceedings, as we know it in the U.S., does not exist.
Right.
So you file all your documents and your request for witnesses with the original claim. You can amend it up to a certain point in the case, but once it's all there, you can ask for more.
Well, it sounds very similar to the French or the Italian system, where the claimant must prove his or her claim and must produce all of the documents on which the claimant intends to rely. And if you don't, and you don't do it without a good reason, you risk that you waive the opportunity to rely on the documents later on.
Absolutely.
Can you get any discovery at all? If the other side has a particularly important and relevant document, not categories of document, but a document, can you ask for that document?
You can, but there's a provision in Brazilian law that says that no party will be forced to hurt itself. So if producing a certain document may hurt that party, he or she doesn't have to do
it. Okay, wow. What's the average time of a case from start to finish, let's say in Rio or São Paulo?
If it's a simple case...
Right, in the court of first instance. Or trial court.
Trial in Brazil is always a trial by the judge only. Trial by jury is only in case of a crime against life.
Okay.
So it's very difficult to have a trial by jury. If you have a regular case with a reasonable degree of difficulty, it might take about 2.5 years at a lower level in Rio.
In Rio, okay.
The same case in São Paulo could go 4 to 5 years.
Wow.
It's that much of a difference. Having said that...
And then appeals in the meantime, after that?
The appeals would take, the state appellate court would take about a year and a half.
Okay.
Under regular circumstances. Then you have 2 other appeals to the federal appellate court and to the Supreme Court. That could take a year each one. And that is without interlocutory appeals in between.
So a civil litigation in Sao Paulo could take, it sounds, doing the math there, up to maybe 10 years, start to finish, through the end of the appeals. 10 years, let's say.
Start to finish, yes, it could.
And in Rio, 4 to 5.
4 to 5, maybe a little bit more. But we recently worked on a case. When we started working on it, it had been going on for 54 years. And we finished it in 3 years.
Wow.
That's not the rule.
And exception. If a plaintiff or claimant wins in the trial court, the court of first instance, is that decision enforceable, or can it be suspended, or is it enforceable only at the conclusion of all appeals?
It could be enforced in some specific cases. Most important situations it is suspended, but in some cases it could be enforced, at least temporarily enforced. So if there's money to be collected, for example, plaintiff could ask for the money to be placed in an escrow account. So there's some measures that can be taken to advance the enforcement of the final decision.
Okay. So, but the view is that if you win in the trial court or in the court of first instance, you may be entitled to get your money immediately and begin enforcement.
You won't get your hands on it. You'll be able to put it aside.
Okay.
Yes, in some cases you'll be able to do it.
All right. What about fee shifting? Does the winner is the winner entitled to a fair number of or a percentage or all of what they spent?
The winner is entitled to a percentage up to 20% of the value of the case. It doesn't matter how much the party has spent. What is important is the amount of the case. So it's very important in some cases if one of the parties starts a case, if plaintiff starts a case and defendant really thinks he or she is going to win, it's very important to challenge that amount, because that will force plaintiff to pay higher court costs, and plaintiff would ultimately be liable for a higher percentage of legal fees and costs.
So it sounds like it's a very interesting tool to use to discourage frivolous or very high claims, and also to encourage settlement.
Yes, but at the same time, one has to be careful. If you have plaintiff or defendant being a very large corporation fighting against a single individual, judges won't look favorably to that. Yes, okay. That's one of the cases when it doesn't matter if the company is Brazilian or a foreign company. There's a perception that one side is much weaker than the other, and that's not looked favorably upon.
So there may be, let's say, a presumption at times in favor of the weaker party, or the party that's perceived as the weaker party in the proceedings, which if it's a single individual, let's say an employee, it may be a presumption in favor of an employee.
If it's an employee against a company, the presumption is 70%, 80% in favor of the employee.
Really? Wow.
Labor courts in Brazil are quite well known for favoring employee tremendously. But truth be said, employees are, in the majority of cases, they're right. Unfortunately, in Brazil, the labor courts have to exist. About 2.5 million cases per year that are filed.
2.5 million cases
per year, and this is because companies normally will not follow the very intricate, cumbersome, and expensive labor laws in Brazil.
Wow. Well, let's change the topic a bit. Not dramatically, because we're still talking about dispute resolution, and discuss for a second arbitration, or international arbitration. Arbitration between a company from Brazil and a company that's not from Brazil. Until recently, I think it was the case that Brazil had not signed or not ratified the United Nations Convention on the Enforcement of International Arbitration Awards, also known as the New York Convention. Right?
That's correct. The convention was ratified this past January 2007, and it is in line with a very considerable shift in position in Brazil towards favoring arbitration. Not only favoring international arbitration, but also favoring local arbitration. In fact, if arbitration is conducted through entities